facing the police every single day. Hey, Sheri County, this is Sheri County COPWATCH, and I'm going to make a quick comment before I play this. Very bad order. Fort Myers Federal Court, City of Punta Gorda, made an ordinance that you cannot record public officials in a public place while they're doing their public duty. It's insane. We got a lawyer. We took it to court. He went for an injunction because it's so egregious. By the way, they don't have any way to appeal it either. So violated the First Amendment, free speech, press, and redress. There is none unless you take them to court. So I went there. I got an ordinance. I was doing a story on it. I was trespassed. And this judge is basically said, slapping us down on this injunction because it's egregious, because you have the right to record, period, case law everywhere. She said you do not have the right, fuck your redress, and you have to ask for consent before you can record, which is nowhere in the case law. Highly recommend share. We need a lawyer on this. We got the case is done. We shut it down. We can refile. Please let me know if you guys know of a lawyer. But this is a long read. But this is how bad Southwest Florida is. And Sheri Chappell's opinion: you do not have the right to record public officials in a public place, and fuck your redress. Wow. Remember what our founding fathers said: take a goddamn country back, and you're a frog in a pot and it's boiling. Get the hell out and fight.
United States District Court. Middle District of Florida. Fort Myers Division. Andrew B. Sheets, individually. Plaintiff. V. Case No. 2:19 CV 484 FTM 38 MRM. City of Punta Gorda, Florida. Defendant. Opinion and Order 1. Before the court is Plaintiff Andrew Sheets' motion for preliminary injunction, Document 27, and Defendant City of Punta Gorda, Florida's response in opposition, Document 42. The court held oral argument on the matter. For these reasons, the court denies the motion. Background. This is a case about video recording inside a government building. Document 23. The city has a municipal ordinance prohibiting video and sound recording without the consent of those being recorded. The ordinance. Punta Gorda Code 15-48, E. This prohibition applies to City Hall and the City Hall Annex 2 ID at 15-48, D-E. To test the ordinance, Sheets went to City Hall wearing a body camera. One disclaimer: documents hyperlinked to CM/ECF are subject to PACER fees. By using hyperlinks, the court does not endorse, recommend, approve, or guarantee any third parties or the services or products they provide, nor does it have any agreements with them. The court is also not responsible for a hyperlink's availability and functionality, and a failed hyperlink does not affect this order. 2. These are separate buildings, but that distinction does not appear relevant. No party argues the buildings should be treated differently. 2. Once inside, Sheets walked into the city clerk's office and asked for a copy of the ordinance. The city employee behind the counter asked if she was being recorded and told Sheets that she did not consent to recording. Another city employee walked over and refused her consent too. In the end, the city employees gave Sheets a copy of the ordinance, so he left City Hall and went to the city police station. There, Sheets asked to speak with the police chief before an officer issued him a trespass warning. The officer directed Sheets not to return to City Hall or the annex for 1 year. Sheets filed a 2-count complaint, alleging First and 14th Amendment violations. Document 23. These claims are facial and as-applied challenges. Legal standard. A preliminary injunction is an extraordinary and drastic remedy. Munaf v. Jaron, 553 U.S. 674, 689, 2008, internal quotation marks and citation omitted. So preliminary injunctions are the exception, not the rule. Four Seasons Hotels and Resorts, BVV Consorcio Bar, SA, 320 F.3d 1205, 1210, 11th Sir 2003. The point of this relief is to preserve the status quo until a final decision on the merits. Antoine on behalf of IAVSCHBD of Collier CTY, 301 F sub 3D 1195, 1202, MDFLA 2018. To justify a preliminary injunction, the movement must demonstrate, 1. A substantial likelihood of success on the merits, 2. Irreparable injury will be suffered unless the injunction issues, 3. The threatened injury to the movement outweighs whatever damage the proposed injunction may cause the opposing party, and 4. If issued, the injunction would not be adverse to the public interest. Siegel v. Lepore, 234 F.3d 1163, 1176, 11th Sir 2000. Movements must clearly establish their burden of persuasion on each element. Callahan v. USDEPT of Health and Human Services. Through Alex Azar 2, 939 F.3d 1251. 3. 1257, 11th Sir 2019, citation omitted. If the first element is unproven, a court can deny preliminary injunction without considering the others. Pittman v. Cole, 267 F.3d 1269, 1292, 11th Sir 2001. Discussion. Sheets failed to show a substantial likelihood of success on the merits, which is necessary to get the extraordinary remedy of a preliminary injunction. The court, therefore, need not analyze the remaining injunction elements, and it can simply deny the motion. ID. A. First Amendment. The complaint's First Amendment challenge is facial and as applied. But neither the pleadings nor briefing distinguish between the 2.3. The First Amendment protects the right to gather information about what public officials do on public property, and specifically, a right to record matters of public interest. Smith v. City of Cumming, 212 F.3d 1332, 1333, 11th Sir 2000. Like all First Amendment protections, this right is subject to reasonable time, manner, and place restrictions. ID. Here, the court assumes without deciding that Sheets had a First Amendment right to record city employees while they worked in City Hall because the city does not argue otherwise. Having concluded Sheets had a First Amendment right, the court must determine the scope of that right. It is by now clear that the First Amendment does not guarantee access to property just because it is owned by the government. Blodern v. Grube, 631 F.3d 1218, 1230. 3 facial and as-applied challenges are different and subject to different standards. Sheets pleads and briefs the two without much distinction. But the court notes he mainly seeks facial relief to strike down the ordinance. 4. 11th Sir 2011. Instead, courts use forum analysis to evaluate government restrictions on purely private speech that occurs on government property. Keister v. Bell, 879 F.3d 1282, 1288, 11th Sir 2018, quoting Walker v. Texas Div Sons of Confederate Veterans Incorporated, 135 SCT 2239, 2250, 2015. There are several different forums. Christian Legal SOCY Chapter of the University of Cal, Hastings COLL of Law v. Martinez, 561 U.S. 661, 679 and N.11, 2010. One type is a limited public forum. Pleasant Grove City Utah v. Sumyum, 555 U.S. 460, 469-70, 2009. Here, the parties agree City Hall is a limited public forum. See also PUNTA GORDA Code 15-48, d, designating City Hall as a limited public forum. This distinction matters because the type of forum determines the level of scrutiny applied. Keister, 879 F.3d at 1288. Ordinances regulating speech in limited public forums are not subject to strict scrutiny. E.g., Summium, 555 U.S. at 469-70. This forum exists where a government has reserved it for certain groups or for the discussion of certain topics. Barrett v. Walker CTY. SCHDIST, 872 F.3d 1209, 1224, 11th Sir 2017, alteration accepted, quoting Confederate veterans, 135 SCT at 2250. So a limited public forum is not open to the public at large for discussion of any and all topics. ID. And it can be set up to grant only selective access to the class for which it is reserved. ID, quoting ArcEDUC Television NV Forbes, 523 U.S. 666, 679-80, 1998. For that reason, regulating a limited public forum need not be content neutral. E.g., ID at 1225. Instead, restrictions on a limited public forum need only be 1. Reasonable and 2. Viewpoint neutral. Christian Legal, 561 U.S. at 679 and N.11. Here, Sheets did not carry his burden to show the ordinance is unreasonable or viewpoint discriminatory. Thus, he is not entitled to the extraordinary and drastic remedy of a preliminary injunction that enjoins a municipal ordinance before trial. C. 5. Chapter of Association of General Contractors of AMV City of Jacksonville, FLA, 896 F.2d 1283, 1285, 11th Sir 1990, noting preliminary injunctions of legislative enactments must be granted reluctantly and only upon a clear showing. 1. Reasonableness. First, Sheets did not demonstrate the ordinance is unreasonable. To survive a First Amendment challenge, the ordinance must be reasonable. Summium, 555 U.S. at 470. Reasonableness must be assessed in light of the purpose of the forum and all the surrounding circumstances. Blodern, 631 F.3d at 1231, quoting Cornelius v. NAACP Legal Defense and EDUC Fund Incorporated, 473 U.S. 788, 809, 1985. Because the government chooses how wide to swing open the gate of a limited public forum, it may allow access only to certain speakers based on their identity. ID, citing Perry EDUC Association v. Perry Local Educators Association, 460 U.S. 37, 49, 1983. So a speaker may be excluded if he is not a member of the class of speakers for whose a special benefit the forum was created. ID, quoting Cornelius, 473 U.S. at 806. Importantly, a restriction need not be the most reasonable or the only reasonable limitation to withstand a constitutional challenge. Cornelius, 473 U.S. at 809. The government, like any private landowner, may preserve the property under its control for the use to which it is lawfully dedicated. Sentinel COMC v. Watts, 936 F.2d 1189, 1201, 11th Sir 1991, internal quotation marks and citation omitted. Likewise, a government workplace, like any place of employment, exists to accomplish the business of the employer. Cornelius, 473 U.S. at 805. It follows that the government has the right to exercise control over access to the government workplace in order to avoid interruptions to the performance of the duties of its employees. ID at 805-06. Case 2:19 CV00484 SBC MRM Document 45 filed November 23, 19 page 5 of 17 page ID 321. 6. Based on the preliminary injunction record, the ordinance places reasonable restrictions on recording at City Hall given its purpose and context. The purpose of City Hall is to conduct legitimate public business. PUNTA GORDA Code 15-48, D, Document 42-6. And the ordinance restricts recording within City Hall without the consent of those being recorded. Point 4 PUNTA GORDA Code 15-48, E. If someone violates the ordinance and refuses to stop recording, the city considers that person a disruption of city business. ID. According to the city's affidavits, prior unconsented recording created disruptions for employees conducting city business. Docs 42-2, 42-3, 42-4. Videos of several city employees circulated on the internet, leading to death threats, suspicious packages in the mail, and so many threatening calls that the city had to shut down its phone lines. Docs 42-3, 42-4. Nor does the ordinance completely exclude Sheets or anyone else from City Hall. Sheets can record in any public part of City Hall if he is not recording a person who does not consent. Considering this evidence, the court cannot say a restriction on unconsented recording is unreasonable considering City Hall's purpose and these circumstances. See Cornelius, 473 U.S. at 809-10, stating the government need not wait until havoc is wreaked on its workplace to restrict access to a non-public forum. As the Supreme Court noted, restrictions on limited public forums need not be the most reasonable or only reasonable limitation to survive a legal challenge. ID at 809. Still, says Sheets, the ordinance is unreasonable because it does not limit the time someone may be barred from City Hall. So as the argument goes, the ordinance allows law enforcement to expel violators for unlimited lengths of time. Yet the ordinance simply empowers city employees to ask the police to issue a trespass warning. Nothing in the 4 exempted from this prohibition are public meetings and law enforcement activities. 7. Ordinance signifies that city employees control the duration of the trespass warning. Further, Sheets' ban is limited in time, 1 year, and geographic scope, City Hall and the Annex. Weighed against the city's evidence, Sheets offers no legal support for saying this limited restriction is unreasonable. Nor has Sheets pointed to a single instance in which the city issued open-ended bans from government property. Sheets also asserts the ordinance is unreasonable because City Hall has surveillance cameras, so the city is disrupting business with unconsented recording. Yet the ordinance exempts law enforcement activities. PUNTA GORDA Code 15-48, E. And using security cameras in a government building is almost undoubtedly a law enforcement activity. In any event, without more, the city using security cameras would not open the limited public forum to unconsented recording by visitors. Thus, the court determines Sheets failed to carry his burden on reasonableness. 2. Viewpoint neutral. Second, Sheets did not show the ordinance is viewpoint discriminatory. A restriction on speech constitutes viewpoint discrimination when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Jackson v. McCurry, 762 FFX 919, 930, 11th Sir 2019, quoting Rosenberger v. Rector and Visitors of University of Veer, 515 U.S. 819, 829, 1995. Viewpoint and content discrimination are separate, but related concepts. E.g., Reed v. Town of Gilbert, Arizona, 135 SCT 2218, 2229-30, 2015. Content-based regulations target specific subject matter regardless of whether they discriminate among viewpoints within that subject matter. ID at 2230. Whereas viewpoint discrimination is an egregious form of content discrimination because it targets not subject matter, but particular views taken. 8. By speakers on a subject. Rosenberger, 515 U.S. at 829. For example, a law banning the use of sound trucks for political speech and only political speech would be a content-based regulation, even if it imposed no limits on the political viewpoints that could be expressed. Read, 135 SCT at 2230. Here, the ordinance is facially viewpoint neutral because it does not target any viewpoint, ideology, or opinion. Rather, it regulates the conduct of all City Hall visitors equally without regard to viewpoint. Put another way, the ordinance applies the same to everyone, no matter why they show up at City Hall with a camera. Unconsented recording and the refusal to stop is defined as a disruption of city business under the scheme. But that does not mean, as Sheets suggests, it targets viewpoint. To circumvent its viewpoint neutrality, Sheets contends the ordinance poses a risk of viewpoint discrimination because it does not constrain city employees' ability to withhold consent to be recorded. That is where the unbridled or unfettered discretion doctrine comes in. See Southworth v. BD of Regents of University of Wisconsin SYS, 307 F.3d 566, 574 N.4, 7th Sir 2002. It is long settled that when a licensing statute allegedly vests unbridled discretion in a government official over whether to permit or deny expressive activity, one who is subject to the law may challenge it facially. Barrett, 872 F.3d at 1220, quoting City of Lakewood v. Plain Dealer PUBLG Co., 486 U.S. 750, 755-56, 1988. Maybe the plainest example of an unconstitutional grant of unbridled discretion is a law that gives a government official power to grant permits but that provides no standards by which the official's decision must be guided. ID at 1221. In that case, the official can grant or deny a permit for any reason she wishes. ID 9. There are several problems with Sheets' unbridled discretion theory. The most glaring is the standard for preliminary injunctions, and Sheets has not pointed to a single case applying this doctrine to a similar speech restriction. Some others follow. First, Sheets says the city conceded that the purpose of the ordinance was to grant city employees with unbridled discretion to restrict recording. As the city notes, this is an inaccurate characterization of the briefing. Rather, the ordinance seeks to prevent disruptions of the city's legitimate public business and rendering public services, along with fostering a safe and orderly environment. Document 42-6 at 1-3. As discussed, the ordinance is a reasonable restriction to fulfill that purpose. And Sheets presented no evidence to make the court question that purpose. Neither party located any cases directly on point, but the court found one somewhat helpful. In United States v. Geleno, a court considered whether an audio and video recording ban was unconstitutionally overbroad. 350 F sub 3D 910, CD Cal 2018. There, Geleno went to a federal courthouse with a video camera to film a public meeting of a local police oversight commission. ID at 913. When Geleno tried to bring his camera inside, court security officers, CSOs, stopped him from doing so. ID at 913-14. No court was in session that day. 5 ID at 916. The courthouse had a policy allowing cell phones and computers but prohibiting their use for taking pictures and recording sound or video without approval. ID at 915-16. Geleno argued the CSOs had unfettered discretion under the policy to prevent recording of public meetings. ID at 915-16. The court disagreed, holding the CSOs did not have or exercise unfettered discretion. 5. This fact is relevant because the constitutionality of recording prohibitions in courthouses is well established. E.g., United States v. Hastings, 695 F.2d 1278, 1280-84, 11th Sir 1983. 10. Because they needed to ensure the safety and privacy of both the judges and staff and make sure they were not photographed or filmed without their consent. ID at 916. As described below, the ordinance allows far more recording and far less discretion than Galeno. This ameliorates the risk of unconstitutional viewpoint discrimination. Second, any discretion individuals have to prevent recording is necessarily limited. Under the ordinance, people can only withhold their own consent for recording of themselves. Put another way, nobody can withhold consent to record anyone else. Nor can a person prevent recording of City Hall's public areas. So while the ordinance does not delineate standards to guide withholding consent, any vested discretion is not unbridled or unfettered, rather, it is personal and limited to each individual. Here for instance, Sheets recorded the lobby of City Hall before encountering anyone. Under the ordinance, no city employee could prevent him from doing that. Similarly, if Sheets had consent to interview someone, a city official could not prevent him from doing so. This limitation on consent ensures no person, city employee or otherwise, can completely prevent First Amendment activity. Thus, Sheets failed to show the ordinance grants unbridled discretion sufficient to justify a preliminary injunction. Interestingly, the ordinance likely allows more speech than necessary. For instance, if the ordinance simply prevented all recording, it would probably be reasonable for the reasons described above and there would be no discretion to analyze. So the court would simply decide whether the restriction was viewpoint neutral. See Kushner v. Berta, No 16 CV 2646, SRN/SER, 2018 WL 186-6033, at *9-11, D. Minnesota April 18, 2018, holding a complete prohibition on video recording a speech in a limited public forum was constitutional because it was reasonable and viewpoint neutral, aft. 771 F. Apex 714. 11. 8th Sir 2019. Even so, the court cannot conclude Sheets clearly showed he is entitled to relief simply because the ordinance allows more speech by allowing consented recording. In Bloedern, a public university prohibited outside speakers in a limited public forum on its campus. Bloedern, 631 F.3d at 1234-36. Yet the university allowed outside speakers the opportunity for speech in the forum if they were sponsored by the university or one of its groups. ID. So like here, the speech policy in Bloedern allowed more speech if the speaker obtained the sponsorship, i.e., consent, of the school or a school group. Still, that scheme was reasonable and viewpoint neutral. ID. The 11th Circuit considered this alternative avenue for speech as a basis to justify its conclusion that the plaintiff failed to establish a substantial likelihood of success on the merits of a preliminary injunction request. ID at 1242. Third, the ordinance is not a licensing or permitting scheme that grants city officials with discretion to allow or disallow speech. Instead, it simply penalizes unconsented recording that becomes a disruption of city business after the person refuses to stop. To the extent that the ordinance grants discretion, it vests any person including government employees and even Sheets with the power to withhold consent to record them inside City Hall. PUNTA GORDA Code 15-48, E. All the same, says Sheets, because government employees are among people who can withhold consent, they have unbridled discretion. Sheets cannot cite a single case that supports this theory. This is likely because the doctrine typically applies in a very different context where one or more government officials have unbridled discretion to license or permit speech. See generally 1 Rodney A. Smalla and Nimmer on Freedom of Speech, 616, 2019. First Amendment concerns are inherent in such a scenario because the officials are left 12. With unchecked power to engage in viewpoint discrimination. Barrett, 872 F.3d at 1226. What those cases do not address is the situation in which everyone, including a plaintiff, merely has the power to withhold their own consent. While not discussed by the parties, the court located one case relevant on this point. In Bell v. City of Winter Park, FLA, the 11th Circuit held an ordinance granted unfettered discretion for private citizens to prohibit speech. 745 F.3d 1318, 1324-25, 11th Cir 2014. Bell, however, differs. There, the forum was a traditional public forum, parks and sidewalks, which enjoy a much higher level of protection than limited public forums. ID. What is more, the ordinance in Bell enabled citizens to prohibit speech entirely, like a typical unbridled discretion case. ID. But the power to withhold consent here is far more limited. Finally, there is a question of whether the ordinance is a prior restraint at all. A prior restraint on expression exists when the government can deny access to a forum for expression before the expression occurs. United States v. Franson, 212 F.3d 1231, 1236-37, 11th Cir 2000. Here, anyone can enter City Hall and record a non-consenting person without punishment or exclusion. So the ordinance appears to be a subsequent punishment, which regulates a given type of speech by penalizing the speech only after it occurs. Barrett, 872 F.3d at 1223, see also Otto v. City of Boca Raton, FLA, 353 F sub 3d 1237, 1271, S.D.FLA 2019, holding ordinances were not prior restraints because they penalized speech after it occurred rather than establishing a permitting scheme to allow the government to prevent speech in advance. The 11th Circuit left open the question of if the unbridled discretion doctrine could somehow be applied beyond the context of prior restraints. Barrett, 872 F.3d at 1222. Sheets argued the 13. Ordinance is a prior restraint because it prohibits recording unless and until consent is given. The city disagrees, so does the court. The ordinance does not penalize unconsented recording. Instead, it penalizes the subsequent refusals to stop recording without consent or leave City Hall because they disrupt the purpose of the forum. In short, Sheets failed to carry his significant burden for the extraordinary and drastic remedy he seeks on the First Amendment claim. B. 14th Amendment. Next, Sheets brings a procedural due process claim under the 14th Amendment, challenging the ordinance facially and as applied. Again, neither the pleadings nor briefing differentiate between the two. To pursue a procedural due process claim, a plaintiff must show, 1. A deprivation of a constitutionally protected liberty or property interest, 2. State action, and 3. Constitutionally inadequate process. Catron v. City of St. Petersburg, 658 F.3d 1260, 1266, 11th Cir 2011, citation omitted. Only the first prong needs analysis because Sheets does not show substantial likelihood of success on the merits. Plaintiffs have a constitutionally protected liberty interest to be in parks or other city lands of their choosing that are open to the public generally. ID. This right likely extends to City Hall. Cuellar v. Bernard, No. SA 13 CV 91 XR, 2013 WL 129-0215, at *4-5, WD Texas March 27, 2013. That right, of course, is not absolute. Catron, 658 F.3d at 1267 N.5. For instance, there is no constitutional right to use public parks under all conditions and at all times. ID, see also Banuelos v. Martinez, No 1:15 CV00010 AWI GSA, 2015 WL366-0261, at *3, ed. Cal June 11, 2015, plaintiff does not enjoy a liberty interest to enter into any state office without restriction. And a person may forfeit this. 14. Liberty right by trespass or other violation of law. Catron, 658 F.3d at 1266, Occupy Fort Myers v. City of Fort Myers, 882 F sub 2d 1320, 1338-39, M.DFLA 2011. Under the plain language of the ordinance, when a person refuses to stop recording without consent, that person is a disruption and no longer at City Hall on legitimate city business. PUNTA GORDA Code 15-48, E. If, after being asked to leave, the person refuses, then the ordinance considers the person to be a trespasser. ID. So the person forfeits any liberty interest in visiting City Hall, see Catron, 658 F.3d at 1266, and the city can restrict access to City Hall without impacting constitutionally protected liberty interests, see Harrison v. Palmer, No 4:13 CV 131 WS, 2014 WL11412696, at *4, NDFLA November 5, 2014, collecting cases. Sheets makes no argument for how a person has a liberty interest to visit City Hall under these circumstances. Despite City Hall being a government building, the public has no constitutional right to visit City Hall under all conditions and at all times. See Catron, 658 F.3d at 1267 N.5. The government can control its property for the use to which it is lawfully dedicated. U.S. Postal Survey Council of Greenberg Civic SNS, 453 U.S. 114, 129-30, 1981, citation omitted. So it seems equally clear the city can exclude trespassers and people causing disruptions with a geographic and time-limited trespass warning without violating a protected liberty interest. See Harrison, 2014 WL11412696, at *4, holding a citizen did not have a liberty interest to visit a state agency's office and the issued trespass warnings were not due process violations. While Sheets relies on Catron, that case is distinguishable for two reasons. First, in Catron, several homeless plaintiffs received trespass warnings for being in a public park 658 F.3d at 1266-67. The 11th Circuit clarified plaintiffs there were 15. Not trespassing when they were given trespass warnings. ID at 658 F.3d at 1266 and N.4. Whereas, here, the ordinance only allows for trespass warnings after a person is disrupting city business and trespassing. PUNTA GORDA Code 15-48, E. Second, because City Hall is open to the public, like the park in Catron, Sheets claims a protected liberty interest to visit City Hall. Sheets argues he only needs to identify that liberty interest. Yet he is mistaken. Plaintiffs must show not only a constitutionally protected liberty interest, but also a governmental deprivation of that constitutionally protected liberty interest. Arrington v. Helms, 438 F.3d 1336, 1348, 11th Sir 2006. The deprivation portion of that element is where Sheets drops his burden because if a person forfeits the liberty interest, then there has been no deprivation. See Occupy Fort Myers, 882 F sub 2d at 1338-29, Holding plaintiffs failed to establish likelihood of success on the merits because there was no liberty interest in plaintiffs' use of the park. People recording without consent are not using City Hall under ordinary conditions or for its intended purpose. The park in Katrin was open to the public generally, and the trespass ordinance prevented plaintiffs' ordinary use of the park 658 F.3d at 1266-67. The 11th Circuit stated the due process rights at issue were to use the parks under the ordinary conditions in which these parks are made available to the general public. ID at 1267 N.5. While Sheets is correct, City Hall is open to the public, he ignores that it is open to the public to conduct legitimate city business. And the city may limit the use of the property to ordinary conditions for its intended purpose. CID, Occupy Fort Myers, 882 F sub 2D at 1338-39, holding plaintiffs did not have a liberty interest to protest in a public park in any way or at any time. Woodbury v. City of Tampa Police DEPT, No 8:10 CV 0772T30 AEP, 2010 WL 255-7677, at *1-2, MDFLA June 8, 2010. 16. Holding a parent did not have a liberty interest to visit child's school and school district could indefinitely bar parents' access to school to maintain order and prevent disruptions, report, and recommendation adopted. 2010 WL 255-7534, June 23, 2010. Put simply, neither Sheets nor any other person has an absolute right to visit City Hall. So when the city limits the use of City Hall based on a violation of the ordinance, it is not violating liberty interests. See also Vincent v. City of Sulphur, 805 F.3d 543, 548, 5th Sir 2015, holding a plaintiff under investigation for threatening deadly violence against city officials did not have a clearly established right to notice and a hearing before being banned from entering city buildings. At the hearing, Sheets argued he violated the ordinance on purpose because he believes it is unconstitutional, and he wanted a pre-deprivation hearing to argue to that effect. But neither a pre nor post-deprivation hearing was necessary because Sheets forfeited his liberty interest before the deprivation. And the remedy he seeks to invalidate the ordinance was available in court all along. At any time, Sheets could have brought a First Amendment unbridled discretion challenge to the ordinance without violating it. E.g., Lakewood, 486 U.S. at 755-56, any who is subject to the law may challenge it facially without the necessity of first applying for, and being denied, a license. So the argument Sheets was denied due process to challenge the ordinance falls flat. While not dispositive, the court notes the city's argument on factual matters over Sheets' residency. The evidence suggests that he may not be a resident of the city, which might affect the analysis on his liberty interest. Sheets does not address the issue. This is simply another factor supporting the conclusion Sheets failed to meet his burden. 17. Again, the remedy Sheets seeks is extraordinary. And the court cannot conclude he carried his burden on the 14th Amendment challenge. Accordingly, it is now ordered. Plaintiff's motion for preliminary injunction, document 27, is denied. Done and ordered in Fort Myers, Florida this 22nd day of November, 2019. Copies, all parties of record.
Well,
how are you?
cold and rainy.
It is kind of ugly. What can I do?
Yeah. Can I do a sunshine law request to look at the your it's either law, statute, or ordinance you have for the buildings?
For the buildings. Are you recording me?
Yeah.
I would like to turn it off, please.
That's why I'm here to get a copy of the statute.
Well, I don't want to be recorded first off.
That's we're in a public building.
Here will be up a minute for the public record, and we do have it posted here, by the way. So.
That's funny. So why, when you took the job, you didn't think that you could be recorded?
Well, you're recording me now. When I took the job, there was never a question about if you could be, because nobody did, I don't believe, until you came in.
Why, is it a bad thing?
Can I help you?
Yeah, can I get a copy of this ordinance 1872.17?
Sure, it's the same one we emailed to you before. Can you pull that up and print it for him? And what records would you like?
I just want that one again, and to see if you're still doing this illegal act by making this. That's
You
not
want a
legal.
copy of the ordinance?
Yeah,
all
that's
you're
not.
looking
It's
for?
not legal.
Ordinance
Yes.
number, please? What's the ordinance number?
Huh?
What's the ordinance number?
It is 1872-17, and then un-American after that.
What else?
That's it. That's all.
Yep.
Seriously, Sarah. You have my deepest sympathies. Oh. First page, I'm sorry. Let's see what-
It was one of like five, 4 or 5 properties that are involved.
Is that because it hasn't been used colors?
No, it's because the
I just printed the first page.
Oh.
Does it state in here what happens if you do then? I mean, you get arrested, shot,
We've provided the
trespassed.
record that you
Right.
requested, Andrew,
Right.
so if you need anything else, just let us know. But we're
Okay.
telling you again,
Right.
you are not to record. It is recorded.
So there's
You don't have our permission to
That-
record us.
That's you're a public official in a public building.
This is a staff area, it's not a public meeting
There is
area.
brochures.
Okay, let's,
right here.
instead of arguing, do you
So-
need any other records?
So
today?
no, there's more of us, and we'll be sending more people here
Okay.
because it's.
All right, very
Wow. Hello. The phone. That's no fun. I like yelling through the glass. Yes. Is the police chief in? No. No, but I'm a reporter, and we've been having problems with getting audio and video from the cars, and I want to talk to her to see if they fixed it. All right. Yep. She's not here?
No, she's not available.
All right. Anyways, so on the police recordings on the cars and oh, you don't got body cameras yet. I wish. All right. I used to have tons of problems with when Tom was here. I've gotten like I guess for audio and video like 78 times, including the last time here since she's been here with Jimenez and the Mexican guy that we're pulling over the black family over here. Okay.
Okay.
All right. So anyways. So Jimenez car, he's a big, tall, black guy, right?
Yeah, it's
Okay.
Jimenez.
Okay, anyways, so his stuff worked great. I go, and then I want the Mexican stuff because he's right
It's
there.
not referring to him as the Mexican.
Right. Okay, what is he?
Hispanic.
Okay, it's the same thing.
No.
Why?
It's a little nicer term. But go
Is-
ahead.
Okay, yeah. Which country is he from?
Mexico.
That's
He
weird.
could be Hispanic.
So, anyways, so
Before we
his
go any further,
right.
this is what we're going to do. The chief's not available to speak to you
Right.
now. Okay, so this is what you got. This is a trespass warning for City Hall and City Annex, okay, for both addresses over at City Hall. You'll no longer be on that property for the period of 1 year, or you will face arrest.
Do I have an appeal?
No,
Why not?
you don't have an appeal.
Because
You don't have an appeal.
because by law you have to.
No, the city clerk wishes to have you.
Okay, so that's why I'm here.
The chief is not available.
Because I felt threatened, and you think that you don't have the right to record there?
You don't have a right to record. There's a city ordinance in place.
So what? My stuff trumps
You can
your stuff.
You can record here all you want, okay? I have no problem with you recording.
Then why is this different from over there?
Because that's a different facility.
And I have no appeal?
No appeal.
That's illegal.
All right. Okay, it is what it is. You can call your attorney. You're trespassing from that property. You cannot be there for the period of 1 year.
You guys
Okay.
are sad. Okay, one more thing. I
Okay.
did, no, hey, sir, stop. Sir, I did find out that you can look at the video and give a ticket. I have the case law on it. Do you have a card so I can send you the
That's
case law?
fantastic. I'm happy for you.
You have a card so I can send you the case law?
No, I don't. I'll get you one.
Send it.
I'll get you one.
Can I give you my card so you can send it?
I don't need your card.
Very bad attitude, sir. That's why you got an IA. Fuckers. Hey, Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.